Joining us, the House Judiciary Committee has issued another set of subpoenas. This time it's for Hope Hicks and Annie Donaldson. Hicks was the former White House communications director, and Donaldson was a former chief of staff for White House counsel Don McGahn. The committee wants to hear from them and get documents related to its investigation into possible obstruction of justice by the president. CBS News Radio correspondent Steve Portnoy joins me now. Steve, what more can you tell us about this?
Hi, Rena. Well, look, Annie Donaldson was chief of staff to the White House counsel Don McGahn, and she took notes that are now central to the Democrats' inquiry in the House about the substance of what's reported in the Mueller report, and in particular questions about whether the president obstructed justice by trying to order the firing of special counsel Robert Mueller. As well, former White House Communications Director Hope Hicks is named in the report as someone who was texting with Donald Trump Jr. as the president was dictating his son's initial public statement about the Trump Tower meeting. Subpoenas have gone out to both women, both Annie Donaldson and Hope Hicks, at this hour. The subpoenas are demanding the production of key documents along with their testimony next month. Annie Donaldson is being called to appear to give a deposition, and Hope Hicks is being called to appear publicly before the House Judiciary Committee on June 19th.
So, Steve, that's only weeks away at this point. We know the White House's reaction has always been to resist these types of subpoenas and testimony. Do you think that'll continue to be the case? Have we heard from the White House?
We have not heard from the White House. This news is just breaking, but I'm certain that the White House will do what it can to push back against this effort to have these two women come, who were senior aides in the White House, to come before the committee. This follows on Don McGahn's decision to honor the president's request, really his instruction, that he not appear this morning before the House Judiciary Committee. Yesterday, the Justice Department's Office of Legal Counsel issued an opinion that said, essentially it reiterated the long-standing view of administrations of both parties that the Congress does not have the power to compel the testimony of a senior White House official, someone who served within the inner circle of an administration and directly advised the president. Even though Don McGahn no longer serves in that capacity, he was subpoenaed to testify about what he did while he was White House counsel, and the Justice Department's Office of Legal Counsel said yesterday in an opinion that essentially that's beyond the reach of lawmakers. The committee has a different view of this. The Democrat majority says it will enforce its subpoena, and it has a number of options it might pursue, including a contempt citation. But the administration's position is that the White House counsel did not have to appear, that he had absolute immunity from the subpoena. The immunity, I presume the White House would argue, would extend to the chief of staff to the White House counsel and also the White House communications director.
So if the White House were to pursue, which I want to make clear we don't know at this point that is what they will do, is there any way for the House Judiciary Committee to counter that if they choose not to follow through?
Well, the most likely scenario is for the House Judiciary Committee to pass a contempt citation and send it on to the House floor. That's what happened when Attorney General Bill Barr declined to appear before the committee, and the Judiciary Committee moved forward with a contempt citation that's now awaiting a vote before the full House. What would happen after that remains an open question, because normally what would happen under the process that's built into law, under the contempt statute, you'd have the Justice Department pursuing that case in court. It's essentially prosecuting a witness who refused to appear. In this case, the witnesses are people who were very close to the president, and in the case of the Attorney General, sits atop the Justice Department. And the view of Justice Departments in the past, when it's dealt with these sensitive matters, has been to say that those people should not be prosecuted for carrying out the orders of the president. And in this case, Don McGahn was ordered by the president not to appear. So then you look at the possibility of a civil contempt proceeding, which is a more likely scenario, where the House Judiciary Committee or the House of Representatives itself would go into court to try to enforce this subpoena and get a judge to order these witnesses to appear. This will take time, and that may be the White House's strategy. One other option, which is an esoteric and archaic thing that hasn't been employed by Congress in 8 decades, is something called the inherent contempt power. And that is the notion that as a lawmaking body that followed the tradition of the Houses of Parliament under the common law, as a lawmaking body with its own constitutional powers, the House of Representatives could command a person to appear, have them brought before the bar of the House by the Sergeant-at-Arms to be sentenced by the whole body either to a fine or to spend time in jail. Now, as I say, that hasn't happened since 1935 when the Senate brought before it a recalcitrant witness and sentenced him to 10 days in a D.C. jail.
Wow.
But the Supreme Court upheld the power of the Senate to do this in 1935, and that is the standing precedent.
That's incredible that you highlight that from 1935. I want to ask you, though, I mean, is there talk on Capitol Hill that something like that they might pull a move like that?
Well, look, what you do hear the leadership say is that there are many options. That esoteric, archaic issue of inherent contempt is an option. A fine is an option. And Speaker Nancy Pelosi was asked about it last week, and she said that's one option we could pursue. But I think what you're more likely to see is a civil contempt proceeding that would have this being fought out in court. And
that could take weeks, possibly months.
Or years.
Or years, really, yeah. I want to thank you very much, Steve Portnoy, for joining us with this update on these new subpoenas for Annie Donaldson and Hope Hicks. Thank you very much, Steve, for joining us.
You bet.
A tornado watch.